From a criminal defense attorney and ex-state criminal prosecutor, how do you stop cops and ATF agents from taking your guns? That's going to be the subject of this video with specifics. Guys, let's get into it. So first, I want you to know this, some basic ground rules that people get wrong all the time. Cops and investigators, federal agents are allowed to lie to you about almost everything. They're allowed to play mental games with you about what they know, what they're trying to get you or gaslight you into thinking that they know, about making threats against you, about what can happen if you don't do X, if you don't open the door, if you don't close the door, open the window, whatever else the case may be. So you need to understand that, look, and this brings me directly into number one, the best thing you can do, don't answer the door. If you don't have a legal duty to open the door and now find yourself in this viper trap, don't do it. It's really that simple. Even if you want to engage with them though, you can engage with them through a closed door. Even if you don't have like a screen door or something else like that, you can talk through a closed door, which then makes it very clear about the fact you're not waiving or consenting to any entry. You're not waiving or consenting to any invasion of your privacy. You're not waiving or consenting to anything if you're doing it through a closed door. No one's going to be confusing what that means later on in court if someone accuses you of having consented to a search, right? Your closed and locked door is a pretty sure sign that no, you're not interested in buying whatever it is the sheriff's deputies are selling. Number two, maybe you've been stopped in your car. Maybe you did open the door because you didn't realize who was there or you just weren't thinking. And now you find yourself trapped in this conversation. Super important. You need to ask whether or not you are free to leave. Now, I realize that that might sound like you're being a jerk, but you have to understand that the United States Supreme Court has drawn distinctions between, let's say you get stopped for speeding. When the officer is going through his or her business about why were you speeding and going through that portion of the stop, this may be all part of the same face-to-face encounter, but these are different legal encounters because you have the legal encounter, the speeding ticket, where once they've turned on their light deck, they've done the siren at you, you have now been effectively stopped, seized, held. Don't go. If you go, well, you might find yourself in jail. However, once they have finished conducting the business of that, there may now be a point where you've entered into the second legal encounter, the consensual legal encounter. This is why you may have seen a lot of people ask the question of officers, am I free to go? And you may often see that officers don't like to give you an answer because they know that, yeah, the business of the stop is over. Now this is a consensual stop, as ridiculous as that may sound. But this is the reason why you ask that question, particularly if the officer starts to go on a fishing expedition. Maybe they see a firearm sticker you have in the back windshield and they try asking about it. So use your judgment, be firm, but be respectful about asking and putting your foot down about, am I free to go? Number three, it's important that you understand what your rights are and what the law is. So I'm going to try to crash course you on that really quickly. Understand a few things. We have something called the Fourth Amendment in the United States that still means something. Basically, it stands for the fact that you are to be free from any unreasonable searches or seizures. A reasonable search can occur when officers have probable cause and a warrant. Right? They've got probable cause that you've done something wrong or someone has done something wrong. They can take that probable cause, go to a judge, get a warrant, and now they can come in and search. Makes sense. What happens if that person could be destroying or moving the evidence such that they cannot afford to go to the judge to get the warrant? We call this exigent circumstances. Probable cause plus exigent circumstances that the evidence could be getting destroyed or moved, or perhaps something awful is going to happen in the event of a case where we're talking about violence or something like that. Now we're talking about the fact that, yep, officer can intervene, they can come through that door, they can come through that window. That's a different set of circumstances. I want to hear from you. Which tip, which thing did I cover that you found the most interesting? And for the very educated among you, I could have made this video hours long, but I don't want to do that. If I had to make a follow-on video, what great tips and pieces of information do people need to hear? Let me know in the comment field down below. Also, don't forget to hit that like button and stick around to the very end for our ever popular quote of the day. We've got a new guest appearance from a Greek thinker. Now back to the video. Now, something that's tricky but important to touch on is something called the automobile exception. Now, I'm not asking you to like this. I'm not asking you to like really any of this. I'm just making sure that you've heard it for your own benefit. The automobile exception is so called that because that's what the United States Supreme Court and other federal and state courts have been calling it for decades, actually almost a century now. It goes something like this. You are at the peak of your expectation of privacy, your reasonable expectation of privacy in your own home. As you leave your home, your expectation of privacy goes down. Why is that important? Because the government and the courts have said that when your expectation of privacy goes down, so too do the burdens of law enforcement in order to get that search done. So cops need, generally speaking, more evidence, more probable cause to go into someone's home than they need to go into the backpack or the locker of a kid at school where their expectation of privacy might be significantly reduced. That gets us back to the automobile exception. The United States Supreme Court has ruled time and time and time again that you and I have a significantly lower reasonable expectation of privacy when we're driving around in our car or automobile as compared to when we are in our home. Again, not asking you to like it. I'm just telling you this is what it is. If you're asking why, it quickly comes down to two things that the court have pointed to. Number one, the simple fact of the matter that a car, a vehicle is inherently mobile. That goes back to the exigent circumstances, right? If you've got evidence in a car and that car is operable, then there's an inherent factor of will that evidence be moved and or destroyed before a cop can go out and get a warrant. Now, sometimes maybe the car isn't operable, or if it's in police custody, then maybe things can start to change. Again, we're keeping it low resolution. Understand there are exceptions to what I'm talking about. But in the broad picture, anytime you have an operable automobile, we're immediately talking about possible exigent circumstances in the eyes of the courts. Number two, the courts have pointed out the fact that, look, cars are so incredibly regulated that they've decided on your behalf, you're welcome, by the way, that you have a lower expectation of privacy in a car than you do in the bedroom of your own house. Like it or hate it, this is what the courts have said. And as a result, they've created what's known as the automobile exception, where basically probable cause plus we're dealing with a car, odds are overwhelming, cops can go ahead and make that search. Again, there are times when they cannot, but you need to understand that that is the situation. Now, if you want me to do a follow-on video where I'm talking about whether or not they're allowed to search your briefcase in the trunk, whether or not they're allowed to search certain containers within the car, and when the automobile exception may not apply, let me know in the comment field down below. If enough people are into that, I'd be more than happy to make a follow-on video. But just understand, low resolution, they're coming in if we've got a car. And you know when else they can basically always come in? Consent. You don't need probable cause. You do not need exigent circumstances, a warrant, or the automobile exception if they get consent. And that consent can come from you, who maybe is the lawful owner of the car, maybe the lawful owner of the home, the dwelling, or with someone who has enough apparent authority. Apparent authority. Those are the words that you want to burn into your brain. Why is this important? Because maybe you're the only registered owner on your home. Maybe you live alone, but you've got a friend who stays over and the cops just happen to show up at your door for one reason or another. The cops don't know that that person isn't on the deed, isn't on the lease, isn't on the mortgage, whatever else the case may be. And if they can argue successfully in court that, look, we were acting in good faith, we thought the individual we were dealing with had enough apparent authority, odds are pretty good that a judge will let the cops go in to do that search. So you need to understand, hey, your team, that means your family, your friends, your in-laws, whoever it is that's staying with you, whoever it is who can represent to have enough apparent authority, that's a potential legal security risk as far as letting agents, as far as letting cops into your home. Make sure they are educated on the do's and don'ts. Make sure that they know these rules, these points. Even if they don't get much, they need to be able to put their foot down firmly but respectfully. Now, if you're one of the lucky few where law enforcement does have a warrant, you need to understand that even if you resist that warrant, no matter how much crap that warrant might be, even if you know it's false, it's based off false allegations made by an ex or someone like that, you have to understand that if you illegally resist an illegal warrant, guess who winds up in jail? You. Not your lying ex, you. That's the way this is going to go down. If law enforcement shows up with a warrant, make it clear that you will cooperate and let them in, unless you want to watch them bust the hinges off your door, which you will likely be the one to pay for, by the way. However, you do not need to consent to any searches. That's a very important and safe distinction that you need to understand. Number 4, let's talk about raising your rights to silence and to an attorney. Now, these are two misunderstood rights in a lot of different ways. And unfortunately, Hollywood and the media does a lot to mess this up for folks. First off, one of these is much better than the other one. Which one do you think it is? Raising your right to silence or raising your right to an attorney? If you said raising your right to an attorney, you win something. Sorry, not for me, but go ahead and buy yourself a Twinkie or something like that. I don't know.
Tell him about the Twinkie. What about the Twinkie?
Raising your right to an attorney is much, much better for a couple big reasons. Number one, there are limited circumstances, very limited circumstances, where courts have ruled that somebody using silence can be used against them. I know, it's not what was advertised in your Miranda card, right? Where your silence cannot be used against you. There are a couple very limited cases where that can happen. Don't be one of them. That's number one. Number two, if you raise your right to an attorney, theoretically, cops and law enforcement are supposed to back off when they're questioning from you. They're supposed to disengage. However, if you raise your right to silence, they can keep coming at you. All right. So that's a very big distinction, particularly for those of you out there who, let's face it, may not be used to dealing with aggressive cop interrogation strategies and interview strategies. Raising your right to an attorney is going to be much, much better. But about raising this right to silence, you need to understand, I cannot do that for you. Let's talk about real world. In every Hollywood cop show, what happens? You're being interrogated in that dark room with like the cop who's standing on the table with his button-down shirt, sleeves rolled up, his tie dangling. You've got like that one light bulb hanging down from the ceiling that's between you and him. You can see the sweat glistening from his brow, and he's making threats. And then what happens next? Some defense attorney wearing a suit, probably gray, breaks in to that interrogation room with his brown leather briefcase and his styrofoam cup of coffee, laughs at the cops, tell them to scram, and they actually do. I assure you, this is what we call fiction. If I were to try to do that in real life, I'm getting tased when I try to get past the lobby, and I'm probably going to wind up in your cell block in jail. You need to understand this. No one is coming. You have to be able to raise your own rights. Don't get me wrong. There will come a time when an attorney can do a tremendous amount of good for you. One of those times is right now when you're learning some things and you're educating yourself. But right there in the moment, in the thick of it, if you're talking and I'm standing there in the lobby, the cops do not need to let me in. They are well within their rights to stand there and to let you purr. I cannot raise your right to silence. I cannot raise your right to an attorney for you. These are not my rights as your attorney. These are your rights as the guy sitting there in the room. You need to be able to raise them for yourself. And that also means that even if you do raise your right to silence or an attorney, and then you start shooting your mouth off, you start talking again, that's what we call a waiver. More technically, that can also be known as a spontaneous utterance or a waiver of your rights. Either one, take your pick. The prosecutor will be happy that you gave them both arguments against you. So understand again, you can waive your rights after you've raised them. But even if you find yourself doing that, you can then re-raise them again. You need to gain self-control though. And while we're here and while we're talking, I also want to make it emphatically clear because there's a lot of misinformation out there. There is no waiver that you are signing of your Fourth Amendment rights when you go to submit a Form 1, Form 4, or Form 5 for that matter, to purchase a National Firearms Act Title II weapon. We're talking about machine guns, we're talking about any other weapons, AOWs, suppressors, short barrel shotguns, short barrel rifles, destructive devices, you name it. You are not giving the ATF permission to just show up and walk in your basement whenever the heck they feel like. So don't let that be a reason to stop you from going out and participating in our fantastic Second Amendment. Comment down below, join the discussion. What do you think are other important tips for people to know I didn't want to make this video too long. Obviously, there's reasons why law school takes years. I could have made this a lot longer, but if I see enough good tips appear, maybe I'll go ahead and make a follow-on video. Don't forget to hit that like button. And now, of course, to our ever-popular quote of the day. This one's from the Greek thinker Themistocles, who once wrote, "I choose the likely man in preference to the rich man. I would rather have the man without the money than the money without the man." Good one. We appreciate you sticking along. I will see you in the discussion section and in the next video. Take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.